allegedly the DWI case didn't come till December 2022.
That's right. I'm not too sure.
All right. Okay. And it is never funny or a joke to ever talk about harming anyone. You understand? What is happening with your face? That has gotten bigger than it was the last time you were here. You need to go see a doctor and have that looked at. You understand? Side. So you're basically unwittingly making a child a criminal. Why are you doing that? But to that case, how do you plead?
No contest, sorry. I'm just nervous.
That's okay. All right, this is a motion to revoke. And I believe this is criminal trial division.
Yes, sure.
Have you conferred with the state?
Yes, we have an offer.
Okay. And you conferred with probation?
Yes.
All right, court is calling 2020 CR 4576, State of Texas versus Juan Manuel Martinez. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense.
Paul J. Smith for the defense.
Are you Mr. Martinez?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Juan Manuel Martinez who was placed on deferred adjudication in 2020 CR 4576 for the offense of robbery on December 16th, 2020 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Violating condition number 5 in Bexar County, Texas, the defendant Juan Manuel Martinez did then and there fail to report to the supervision officer as directed for the months of October, November 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
And we'll waive the remaining violations, Your Honor.
Objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, there is.
Yes.
Revocation and adjudication and sentenced to 5 years in Texas Department of Corrections.
Defense, is that the agreement?
It is, Your Honor.
Mr. Martinez, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Juan Martinez,
All right, so why didn't you report?
because I had a DWI. I had drinking. I didn't want to get my probation revoked and have my dad work the whole summer, knowing that he needed my help. So I know that I failed to report because I didn't want to.
And when did you pick up the DWI? Is this December 26th?
Yes, Your Honor. On Christmas or Christmas night.
But then that doesn't explain why you didn't report in October. Because you wouldn't have had the DWI until December. All right, because it's saying here that you didn't report for the months of October and November. And according to this, which I'm not saying it, taking it as true, but according to this, allegedly, the DWI case didn't come till December 2022.
Yes, Your Honor. I'm not too sure.
All right. Has he done anything on probation?
I mean, he picked up number 1. So we would do
Yeah, I
that.
mean, yes.
Your Honor, this is his second MTR. As far as what I can tell, he has not done anything. He hasn't completed any of his community service hours. I will say he did pay $1,241 of his $7,625 assessed fees. Other than that, no, ma'am.
All right.
There
Is-
was a negative UA back in December of 2022, diluted in September of 2022. There was a positive in January of 2022.
All right. And with regards to the restitution, was any ever tendered to Mr. Antunes and Miss Villalobos?
Your Honor, there isn't anything under the financial portion that indicated there was restitution, actual restitution numbers, the amount for restitution, so more than likely not.
Okay. All right, the court will find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You want to walk around?
I want to touch the microphone.
Thank you. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Martinez, how old are you?
26.
All right, you're gonna have to start doing better. Because otherwise you're gonna find yourself in and out of somebody's jail and in and out of prison. If you have a drug or alcohol problem, I can request that you be placed in the therapeutic community. Whether they accept you or not will be completely up to them, but at least they can help you address any alcohol or substance abuse issues you have. Would you like that?
Yeah.
All right, so I'm gonna add therapeutic community to his sentence. You'll still need to request it. It doesn't increase the length of time that you've been in custody. So for example, if they're gonna release you in 5 years and you're still working on your substance issues, they're not gonna say, oh, we're gonna keep him. You understand? All right. All right, good luck to you.
I'm not gonna ask her any questions. I want you to speak to her on it. Tell her what you feel. We've discussed this. I didn't tell you what to say. Have I told you what to say? I've just told you to speak from your heart. Tell her what you feel, how you, what you want her to know about you, please.
Mi jurado, en verdad quiero pedir disculpas por todo lo que dije y especialmente los familiares de ella.
Your Honor, I really want to apologize for everything I said,
Especialmente a Ana Flores y sus familias. No quiero ponerse en terror y
especially Ana Flores and her family. I never meant to terrorize them or put them in fear.
yo estaba simplemente bromeando y quería mirar su reacción de cómo reaccionaba y
I was just joking and I just wanted to see how they reacted.
nunca quería cometer ni un masacre ni nada de eso.
I never wanted to commit a massacre or anything like that.
Fue muy estúpido
I was very
diciendo
stupid
eso. Y
by saying
me siento
that,
muy arrepentido por todo.
and I really regret everything.
Do you have any questions?
I do, Your Honor. Mr. Ross, as you heard Ana Flores mention a event in which you went to for child school with her. Do you remember that?
Sí, fiscal.
Yes, the 8th.
And do you remember telling her that you knew which school to shoot up now after seeing that?
Your
school?
Honor, I don't believe Ms. Flores said that he knew what school. I believe she testified that he knew where to go. I think that's how she mentioned it.
All right, I remember all of the testimony.
Right,
My mind's a steel trap.
okay.
So, thank you.
Fue una vez, pero no recuerdo la dirección ni el nombre de la escuela.
I only went once and I don't remember the address or the school number.
But do you remember making that statement to her
Sí.
Yes.
Did you have another coworker named Perla Garcia?
No me acuerdo su nombre, pero probablemente sí tenía otro compañero.
I don't remember his name, but I probably did have another coworker.
Do you remember telling a coworker that her daughter should kill herself when the coworker was
No,
discussing
no,
her
no,
suicide?
to any kind of hearsay.
Judge, these are in the stipulations.
All right, and just so everybody knows, I've read the stipulations, I always read everything and read police reports.
Okay.
And I do it when I take the plea, and I also do it when it's coming up for sentencing. I read everything again, so I've read that, and I've read probation's report. All right, but you can ask your question.
No, nunca he dicho a alguien que se debe que suicidarse ni nada de eso.
I have never told anybody that they should commit suicide or anything of the sort.
Do you remember in this case being interviewed by the police after this incident?
Sí.
Yes,
And do you recall discussing having researched prior mass shootings?
Es muy complicado. Es porque en YouTube siempre hay recomendación de noticias porque
it's very complicated because on YouTube, you always get a recommended news feed
en las noticias, en los canales de noticias.
on the news channel.
Y siempre hay school shooting, massacres y eso, y por siempre morbo.
And there's always mass shooting massacres and you have like a morbid curiosity.
Eso es algo que los miro, pero
And I look at them.
nunca estaba simulando si yo lo haría eso.
But I was never simulating that I would do that.
Pero fue algo como en el momento que intentaba explicar si ellos miraban que por qué estaban
It was a spur of the moment thing. I was trying to explain if they saw something like that
explicar que era solamente por curiosidad
and explain that it was just out of curiosity
y no para planear nada.
and not to plan anything.
And do you recall telling your coworkers that the Uvalde shooter was a hero?
Sí, pero solamente era por una reacción de Ana Flores.
But no, but that was just a reaction from Ana Flores.
Era una broma.
It was a joke.
No es mi héroe ni nada de eso.
He's not my hero or anything like that.
I don't have any more questions, Your Honor.
Any further questions?
Mr. Aceves, do you realize now that you said too much that can hurt you in your future?
Too
Sí,
much.
dije demasiado. No estaba pensando las consecuencias que podía ocurrir y
Yes, I said too much and I wasn't thinking about the consequences it could have.
ya sí comprendo las consecuencias que voy a la cárcel y nunca ver a mi familia más.
Now I understand the consequences that I could go to jail and never see my family again.
Now, you've been on probation for 16 months. And-
Counsel, not on
I mean
probation.
I'm sorry, on house arrest for 16 months. Full house arrest. Have you ever had any violations during the 16 months?
No he tenido nada, hasta era bien precavido que no cometiera ni un error para que pensaban que yo iba a hacer algo.
No, I have not committed any violations. I have been very cautious, so you wouldn't think that I have done something.
And because of that, you've lost your credit rating. You've lost your vehicle, I believe. And correct me if I'm wrong in this thing. Obviously, you've lost your job. You haven't been able to go out to look for a job. And all this is correct.
Sí, es correcto.
Yes, that's correct.
And because of this, you've seen how something so stupid as saying something like that can affect you for the rest of your life.
sí me puede afectar. Debo como casi $10,000 en total.
Yes, it can affect me. I owe at like $10,000 in total.
En 2,000 en la tarjeta de crédito
2,000 on the credit card,
y 5,000 en el vehículo
5,000 on the vehicle.
y como en el tiempo eran como $3,600 por el GPS.
And at the time, it was like $3,300 for the GPS.
Can you promise the court, Her Honor, that she will never see you here again should she give you deferred adjudication?
No puedo nunca cometer ni un crimen ni ser un ciudadano honorado.
And I promise I will never commit a crime and I will be an honorable citizen.
I'll pass away, Your Honor.
Any further questions?
Briefly, Your Honor. Mr. Aceves, how many firearms did you own prior to this incident happening?
Son de uno.
It was only one.
So if the police had found both an AR and a shotgun in your room, did not both of those belong to you?
No era una shotgun, era un air rifle.
It wasn't a shotgun. It
No,
wasn't their
air
rifle.
rifle, sorry. Air. It's the pebble gun or something like that. A pebble rifle. Pellet, yes.
It was a pellet gun or something like that.
No a shotgun.
When was that AR purchased?
En el mes de febrero.
Your Honor, interpreter and petition.
All right, if you'll repeat, please.
En el mes de febrero.
MS.
Oh, sorry. En
February,
month of
in the
February.
month of February.
Was that the same year that this incident occurred?
Sí, pero nunca fue intención de comprarla para planear una masacre y nada de eso.
But it was never my intention to purchase it to plan a massacre or
Tenía
anything.
19 años y quería comprarme una pistola porque cosa más me gustan mucho como mirar TV shows de
I was 19 and I wanted to buy a gun because I love watching TV shows about
como de zombies como de The Walking Dead.
like zombies,
The
like
Last
The
of
Walking
Us y
Dead
eso.
and that.
Y ahí son uno que puede imaginar como que debes que estar preparado por cualquier situación,
And you can imagine that you have to be prepared for any situation.
aunque no puede, definitivamente no ocurre porque es ficción.
But
Pero-
of course not because it's fiction.
Pero no podía comprarme una pistola porque era menor de edad, debía que tener 21 años.
But I couldn't purchase a gun because I was a minor. I had to be 21.
Así que compré un rifle.
So so I bought a rifle.
No further questions.
All right, so are you saying you couldn't purchase a gun at 21, but you could purchase a rifle?
Así es lo legalmente que puedes.
Oh, no.
Yes, that's why you can say that's legally. what
Yeah,
you
no,
can
no,
do.
I know the law. I'm just, that was sort of a rhetorical question,
Oh, lo siento.
I'm sorry.
you know. So are you currently 21,
No,
still 20?
No.
yes. Sí, no, sí, mi jurado.
Yes, you're
All
right.
right. So a lot of people will say sometimes, oh, I've said before, you know how you say, I could just kill that person? And honestly, I don't know anybody who's ever said that about somebody else. So what were you thinking and why would you think this would be a joke?
No quería como hacerle que sí le iba a comentar hacer era
I didn't want to make that comment.
son te diciendo para una reacción así.
It was just to say it for a reaction.
Okay. All right. So I will listen to your arguments, but this is what I want to tell both of you when you give me your argument. So my job as a judge is not like the Minority Report with Tom Cruise. I can't see into the future. I don't know what's going to happen. I know state you're asking for 10 years prison for a 20-year-old. for threats. And I've seen cases where people have made threats against a single person and people offer them deferred or people offer them probation. And I know that's not you, but I've seen that happen. In this case, state, you're going to be asking me to send a 20-year-old to prison for something that I'm assuming you're doing it because you think, one, that he could end up committing this. But what I see is a 20-year-old, and if I send him to prison, and let's say I send him to prison for 5 years or 10 years, and he does all his time at the prison. So let's say he goes in at the age of 20, he's there for 10 years, he gets out when he's 30, they offer him parole, he says, no, I don't want parole. And so he gets out of prison at 30 years old, and he has no supervision, and he can do whatever he wants to do. Then we're right back here. I personally don't think that solves the problem that we have before me. And I will tell both of you, I've read all the stipulations, I've read everything. And based upon what I'm reading and the fact that he has no criminal history, 10 years is too much time for what he's charged with and for what he potentially was saying he was going to do, but didn't do. And maybe he was going to do it, but he was stopped before doing it. I don't know. I don't have a crystal ball. What I am thinking of doing is granting his application, keeping him on deferred for 10 years. He will go into custody today because you're going to go to state ISF cognitive if that's available. If it's not available, we're going to see about some type of, I don't know, mental conditioning or something. I would order that he not to have any possession of weapons. He would still remain on GPS. GPS would be full house arrest, then slowly, maybe he can get a job, then slowly lower down the conditions on that. I would have where he's not to appear or not to reside within a certain place of schools, that he would not be allowed to work or go to Amazon. That's what I'm thinking. And if there's a reason why I should not be thinking that, or someone has something potentially to change my mind about that, I'm more than welcome to hear the argument. But either way, he would be going into custody today.
Your Honor, you're much brighter than I am.
Oh, no.
And I appreciate and I respect your decision, and I think that's a good thing for him. I don't think he needs it, but if the court needs it, then I'm okay with it. I've gotten to know this young man over the last 16 months. And I'm gonna get emotional because I've gotten to like him because he really is, thank you. He really is a good young man. He really said something stupid. And it's not too often in my 35 years of being a lawyer that I get emotionally involved in a case. They tell you not to. But when you really believe in someone, when you really believe that they were acting stupid, for this to happen to them, it's like, what did you do to your life, son? And that's how I feel about him. I would have liked to have seen him just walk out with me. I know in my heart that you will never see him again, but I respect your decision and I'm okay with it.
All right. Well, the court's concern is obviously for somebody to even jokingly say this, there's something mental going on. And I don't, if I had a program that was a free program that was available where he goes into a mental facility and they work, they educate, I would send him there, but I don't have that. If somebody has that and they have where it's private or it's free or somebody's willing to pay for it for him, I would reconsider doing that instead of ISF. But I think right now, because part of my job is also to protect the public. And if I had a crystal ball, it would be great. Because I could say, this is what he's going to do in 3 years. Or if I had a crystal ball and I would say, send a 20-year-old to prison. And we all know prison life, even Bexar County jail life, is not the best life. He's young, he's thin. We already know what's going to happen at prison, potentially, because everybody can't watch people 24/7.
Right.
And I am wondering, sending him to prison for 10 years, what is that going to do to his psyche? And how is he going to come back out of prison into society? And are we going to have an even bigger problem? So I'm trying to put some safeguards in place and then state if he violates GPS in any way that I'm going to give him, if he doesn't report the way he's supposed to, then the full 10 years is there. I will put in place that there, wherever he lives, if he's living with his parents, there are to be no weapons in the home. And I'm going to put in place sort of similar to sex offender registration, even though this is not a sex case, that he has to give probation all the computer access, phone access, any electronic access, so that they can be aware of what he's looking at and what is happening. I just think in this case, 10 years prison for a 20-year-old, and I realize what could have happened, what may have happened. So that's where I am. And the reason, and I struggle with this case, and I thought about this case from when you all were first here till now, about what potentially would be the right decision in this case. And it's a very difficult case. And I know it's a difficult case for the state. And state, I do know why you're asking for the 10 years, because something catastrophic could have happened. So I do understand.
And I respect her for that. And just one more thing, if I may. It's been comforting for me to know that he's been on full house arrest for 16 months. 4 days would be 16 months. He didn't even walk out the front door. And I think that goes to show you that I feel that he's going to be successful in this program. We appreciate what you're doing for him. I just have one question. How long is this going to take? I don't understand. I don't know. Unless
Probation will be able to let you know how long it will take for him to get transferred to state ISF. But again, if you and the state want to confer and there is some sort of inpatient cognitive treatment for him that is not at the state jail or not at the prison, you can let the court know. The court will consider that. But my thing is, he needs to be worked on internally with the mental that's going on. And I see there are some mental health issues, but DDRF and Mick, they say he's not eligible.
Right. I understand your decision, Your Honor, and I do respect that, and I do agree that some sort of inpatient time, if we're not going to send him straight to prison, is appropriate. I'm thinking back to what Mr. Porter had testified last week, that it remains to be seen whether this is someone who's done well on bond because they fixed the problem, or if they're doing well on bond because, as Mr. Osbus had testified, I've been cautious so you won't think I've done something. So I think that we do need as many safeguards as possible if we aren't doing prison, and short of that, to ensure that.
Well, my thing is, we're going to do things incrementally. And we will have settings for this to come back to court. Once he's released from inpatient, we can have settings to come back every 60 days, and we can discuss where we are, how he's doing, and do it that way.
One more thing. I keep saying one more thing.
Yes.
I love coming to this court, Your Honor, because you not only think of the public, but you also think of the welfare of the people that are before you. And that's just something that you've earned the respect of all of us in Bexar County and anybody else that may know you, that you're just a wonderful lady.
Oh, thank you so much. I appreciate that. All right. So I'm going to give these conditions and state if there are any other conditions you think would be helpful, just let me know. So we're going to do 10 years deferred adjudication. There is to be state ISF cognitive. And he's to be taken into custody today for that. Once he's released from state IS cognitive, we will set this, Vashawn, once he's released from state ISF, before he's released from the Bexar County Jail, let's have him brought over. Is that possible? Okay, well, let's do this. Once he's released from state ISF, we'll just set it for a hearing in here and we'll call it a compliance hearing.
Yes, ma'am.
So once he's released, we'll do a compliance hearing to maybe fine tune any conditions that we need to fine tune. So I'm going to say full GPS, we'll waive fees
Yes, ma'am. Thank you. I was gonna ask.
or defer fees. And then Mr. Aceves, once you've completed the state ISF, or if there's an inpatient treatment through private means, once you completed that, we're going to come back and then we can address the full GPS. But my understanding from working in different treatment courts, you can't go from rigid to all of a sudden you're free. It's sort of like when you have children and you have them on this rigid schedule, then maybe you send them off to college and no supervision. So we'll do full GPS. There's to be no weapons possessed. And there's to be no weapons wherever you're living. So if you're living with your parents, there's to be no weapons in the residence. You understand? And to the Mr. Cisneros, if you could let his parents know, if there are weapons in the home, he cannot stay there.
Yes, ma'am. And Your Honor, he was saying that he owes like $3,000 or something in the GPS fees. Is there a way we can waive those?
We'll deal with that when we come back.
Okay, thank you.
All right, there is to be all electronic, I'll say just items. So that means computers, cell phones, sort of like if he were on sex offender registration. He's to make sure that you all have all the information to look into those computers. So you're going to have to register all electronic items, and that's going to include the items that your parents have in the home. So if they have cell phones, iPhones, all of that has to be registered. You understand?
Yes, Your Honor.
And all computers in the home must be registered. There's to be no contact with Ana Flores or any workers from his Amazon location, because I know people will order off Amazon. So none of the workers from his Amazon location. There's going to be regular reporting. That can be by Zoom or in person. I'm going to want random field visits, one time per month until further notice. And Vashawn, if you'll let probation know when we have the compliance hearing, if that's going well, we can reconsider. There's to be regular UAs. And we will deal with proof of employment. Vashawn, I'm not even going to put employment in right now because there's no way for him to get the employment. We'll put that in once we have our compliance hearings. Vashawn, is there anything else he needs? Mr. Aceve, I keep mispronouncing your name. I'm sorry. Is there anything else you need from the court to be successful?
Voy a ver todas las condiciones.
No, I will obey all the conditions.
All right, State, do you think there's anything else he needs at this time?
No, Your Honor, but Miss Ana Flores did mention to me this morning that she would like the no contact order to extend to her family.
Yes.
Based on the concerns that she mentioned earlier.
All right. And there's to be no contact with Ana Flores's family.
And for the record, Your Honor, I'd like to tell Mr. Aceves something. And that includes your family, your mom, your dad, any family members or friends, okay? They cannot contact her at all. Okay?
All right. And then I'll put in here, there's to be no contact with elementary, preschool, junior high, high school. I think they now call it middle school. If he decides that he wants to maybe get his GED or get a college degree, we'll cross that bridge when we come to it. But for now, there's to be no contact with any schools. All right. Is there anything else from either side?
No, Your Honor.
All right.
No, ma'am, thank you so much.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Sí, mi jurado.
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Sí, mi jurado.
Yes, Your Honor.
All right. So from here on out, everything that you do, you're looking at potentially going to prison for 10 years. Do you understand?
Sí, mi jurado.
Yes, Your Honor.
And I hope that you're going to be thinking about what brought you here. Okay? And it is never funny or a joke to ever talk about harming anyone. You understand? That's not funny. Okay. Oh, no problem. Yes. All right, everyone, make sure you keep your voices down, please. Court is calling 2020 CR 2517, State of Texas versus Humberto Chavez. Can I have parties announced for the record for the state?
Jason Gearhand, Your Honor.
Your fence?
Adrian Bettis.
And are you Mr. Chavez?
And Your Honor.
All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Humberto Chavez who was placed on community supervision in 2022 CR 2517 for the offense of possession of a controlled substance, penalty group 1 less than? All right, does anyone want to make a oral motion to the motion to revoke?
Yes, Your Honor, oral motion to change the verbiage states possession of controlled substance penalty group 1 less than 1. It says group, we're asking for less than 1 gram.
No objections.
All right. So are you the same? All right. Are you the same Humberto Chavez who was placed on community supervision in 2022 CR 2517 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on June 6, 2023 for a term of 3 years? Is that you?
Yes, Your Honor, it is.
All right, state.
Yes, Your Honor, violating condition number 1 on or about the 25th day of August 2023 in Bexar County, Texas. The defendant, Humberto Chavez, committed the offense of evade, arrest, or detention in violation condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, we'll waive the remaining violating conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
I'm sorry, everyone, just one moment. Can you mute us, please? I'm sorry about that. It's usually those are medical appointments, so I need to answer them because they're medical appointments for people in my family, okay? All right, so did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor.
And what is the agreement?
The agreement is to adjudicate guilt, revoke the individual office probation, sentence him to 180 days in the Bexar County, I'm sorry, not the Bexar County, the state jail facility. And also the state will take into consideration the 2 new number 1s, cause numbers 715.
Everyone, please whisper.
715-748 and 715-749.
All right, is that the agreement?
Yes, Your Honor.
Mr. Chavez, are you asking the court to follow that agreement?
I am, Your Honor.
Are you waiving your right to appeal?
I am, Your Honor.
All right, the court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served, take in consideration 715-748 and 715-749.
Your Honor, our agreement was for 180 days.
Oh, I'm so sorry.
That is.
Yeah, I was just seeing if people were paying attention. All right, I'll follow your agreement to 180 days in the state jail facility. Mr. Chavez, you do have, it appears that you have a drug or alcohol problem. If you would like, I could refer you to the therapeutic community. Whether they place you in the program or not is completely up to them. I don't have any jurisdiction over that. However, if you were placed in the therapeutic community, it will not extend your 180 days. So would you prefer that or no?
No, Your Honor, actually, I'd like to just be done with.
All right. So here's the thing. If you don't get your life together, you're going to be back right here with another drug case. Do you understand?
I understand, Your Honor.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I did, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do, Your Honor.
All right, we can go off the record. Mr. Chavez, I remember you, and I will tell you. It will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Elsa Mireles.
All right, why are you stealing?
That was a bad choice. I wasn't thinking.
Why are you involving a child in theft? Because it says that this was the MO, go to the store, put things in a cart, and then have a child push the cart outside. So you're basically unwittingly making a child a criminal. Why are you doing that? I mean, your attorney was not there, so he can't answer this question. You did it. You took a child in Target, or as we say, Target. You took a child there, loaded things in a basket, and for that child to know to just push that cart towards all points of sale tells me that somebody told that child, this is what's going to go down. We're going to go in, we're going to put items in this cart, and you just keep pushing it. So why?
I have no words for that.
Yes. And how old was the child that you all involved in your criminal activity who now thinks it's okay to engage in criminal activity?
5 years old.
All right. So you took a 5-year-old. And what day of the week was this? Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, what day?
I'm not sure.
All right. Was it a school day?
No, I'm not too sure.
All right. So you take this 5-year-old, walk me through it. So the 5-year-old is pushing the cart out, and obviously police are called, right?
Right.
And did they speak to the 5-year-old? What is the 5-year-old thinking? Do you know? I know somebody will probably object to speculation, but I just want to know, what was the 5-year-old doing when police are there? I'm assuming you all were placed in handcuffs.
I was already in the car. It was with his mother.
Mhm. All right. So it was you and his mother who was stealing. Is that what you're saying?
We were already out and the mom told him to leave it there and he did it.
I'm sorry, I can't hear you.
Somebody else helped the little boy push it out.
All right. So someone helped the little boy push the cart out after you all were committing a theft from Target. And what items were you all taking?
It was stuff for the kids.
No. Don't put this on the children. What items were you taking?
Toys.
And what else?
clothing.
So you're teaching children that in order to get things, they should steal. That's what you're teaching. And you left out to the tune of $553.69. So how full was the cart that you were taking out?
It was full.
All right. And then now I've received this letter where you took a child to help you steal, and somebody is saying that you're taking care of children and you're a home health care provider. I don't allow people in this courtroom who are on probation to be home health care providers. And who are you providing health to? Is this a relative?
No.
Right. So I don't know how you're able to take care of children and be a home health care provider.
Those are my kids that I take care of.
Mhm. I don't think you're a good candidate for probation because it appears that your background is littered with theft cases and you're here on a theft enhanced. And how old are you?
43.
I mean, you're old enough to know better. It's not like you're 20 or you're 19 and you have peer pressure. So again, tell me, why are you stealing? It says here that you have a job, that you can pay for things. I don't understand the stealing.
Your Honor, but that doesn't excuse for it.
I'm sorry, what?
I didn't have a job at that time, but that doesn't excuse.
Yeah. And it certainly doesn't excuse involving a 5-year-old in your criminal activity. So again, why should I give you probation? The state is silent. Why should I give you probation?
Because I gotta take care of my kids. There's no fathers involved for my children.
Well, when you were using the 5-year-old to steal items, were you thinking about, who's going to take care of my children if I am at the Bexar County Jail? Were you thinking about that?
No, Your Honor.
And if something would have ended up happening, sometimes when people go to places and they steal, sometimes people end up getting shot. If that 5-year-old would have been shot, you know what would have ended up happening? You would have been on somebody's news, boo-hooing and crying about how it's unfair that your child was shot. So what am I supposed to do about this? You won't stop stealing.
I will, Your Honor.
No, did you say that to the last judge, that you were going to stop stealing? How many times in your lifetime on this planet, as a 41-year-old, have you had criminal cases for stealing? Now, mind you, name them all because I've read the report.
Like, I believe 5 cases.
And you have not learned anything from that. What you've learned, obviously, is to continue to steal and start this idea where you take a child in with you, you put items in a cart and you just have them pushing it out. In my mind, I can imagine this 5-year-old, because when you see children pushing carts, they're not even old enough to stand and look over the cart. They're just struggling, barely pushing it. And I'm always thinking to myself, why doesn't a parent help that child push their cart?
Your Honor, we told him to leave it there and he continued pushing it out. That's when the other 2 people helped him.
Oh, so now you're saying
Yeah, that's what we did.
you did not include him in your criminal enterprise.
We told him to leave it there and the other 2 people, random people, helped him.
Oh, so this is not a theft case. You were not intending to have him steal. Is that what you're telling the court?
That's what happened.
No. Are you telling the court that this was not a criminal enterprise, that you or somebody loaded a cart at Target with items, the 5-year-old was pushing it, and you're continuing putting items in a cart totaling over $500. And then as he's pushing the cart past points of sale, you're telling him, oh, just leave that there. Maybe you're telling him, we don't have money for that. We just loaded up the cart for some unknown reason and we have no money for that. Is that what you're telling the court? If not, let me know. I mean, I wasn't there. State wasn't there. Your counsel wasn't there. I'm just trying to figure out if that's what you're telling me. If that's not what you're telling me, say, Judge, no, that's not what I'm telling you. I'm not going to take that as a sign of disrespect, okay? So are you telling the court that you all loaded up a cart of items at Target? The 5-year-old is pushing the cart and you're telling the 5-year-old, leave the cart there. We don't have any money for these items. And your intent was just to walk out. Is that what you're telling the court?
To walk out without the stuff, like to leave the stuff there.
Okay. Is there anything else?
Judge, with this testimony elicit from my client at this time, I think we need to ask the court to withdraw her plea.
All right, that'll be denied. All right, this is what the court is going to do. Court is going to find you guilty. Court is going to sentence you to 1 year in the state jail facility. Give you credit for any time served. Take in consideration GJ 812055, JN number 2127782. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Good luck to you. Do not steal, do not take what does not belong to you, and do not involve children in your enterprise.
TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez.
Yes.
All right. And is that the Rebecca Martinez who's on the fourth court?
Yes, Judge.
Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that was fair and right in this case, so no objection.
All right. So are there any witnesses that anyone wishes to present? State?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant,
All
which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter, I will be speaking and Ms. Segundo may say a couple of words, and Ms. Segundo's parents are present in support of her today. They can stand with Mr. is standing here in support of her today.
All right. Thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gracie Segunda.
All right. And with regards to County Court Cause number 6933701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just so nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
I will go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 6933701, how do you plead to that? All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? Right. So the court then will hear argument. State you're opposed to deferred adjudication.
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense.
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career in taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of, it was just something in her reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agree to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely has nothing personal against Miss Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I don't know, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that fight.
I went to go and try and pull my friend away and then I don't know, it was just a bunch of people and somebody hit me and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's what we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. If you want to see it, Judge, it's public record.
I would object just because relevance.
So lawsuits and filed in the city court, that's a copy from the courthouse.
All right, unless there are some facts that are listed in the,
It pleads the
Lawsuit.
whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, well, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will,
It does not, Judge.
all right, so,
But just to let you know, there is a civil suit.
all right, then the objection will be sustained.